Good morning, everybody. I'm Dr. Mike. I'm the host, but I'm going to give the word to Dr. Tom. He's going to briefly introduce himself, and then obviously our topic today is about the trust. If you have questions, just write them down. We're going to have a Q&A at the end. Therefore, we don't interrupt Dr. Tom during his presentation. Write your questions down, and we will have time available at the end to answer those. So with that said, Dr. Tom, the word is yours.
All right, thanks. All right, today's talk hopefully mostly about trust law. Originally, I thought I was going to be over the military occupation, so I sent some stuff out on the transitions of your American citizenship all the way to a U.S. citizenship. But basically, who am I? I'm a guy that's been studying for many, many years on this kind of stuff. I spent at least 5 years traveling the country. I even went to Canada to see Dean Clifford, Robert Menard, studied Winston Shrout, Jordan Maxwell, Brandon Alexander, Jack Smith, Gordon Hall, a variety of people. Spent years getting their DVDs, looking at stuff, reading, getting a little information from everybody, trying to put the big puzzle together. And that was really the hard part of the journey. And what took years to me was you learn a little bit, you're trying to put it together into one big picture that makes sense. Now, later on, a guy by the name of Brandon Alexander was teaching creditors and commerce, more like the SBC stuff. But really what he was teaching was private trust law. And if you took his class, it was a year-long class where we traveled like 4 different cities every 3 months, and we were creating these private trusts, learning what a trust was, learning the trust structure, learning the trust language. And only until I learned that aspect did the learning for all of this become much more exponentially quicker. So what I'm trying to tell you from my viewpoint is once I learned about trust, everything else that you've learned or want to learn will come much quicker if you can put everything in terms of a trust, because that's what's going on all around you, are all of these trust agreements. Okay. So, I do have students, but I am different from Anna. I am different from David. I've read all of Anna's stuff. I've read all her books. I've read all her 3,500 articles. I looked at her stuff for a long time. I've looked at David's stuff. I don't do either one because I think both of them have faults in them, which I'll point out a few in my talk today. But let's get back to trust law. Why trust law? Why do you have to learn it? Why do I feel it's so damn important? Well, trust law is also called natural law, and it's also called God's law. Trust law is the highest form of law on the planet. Okay, it is the superior. Even the elite follow trust law. I know everybody thinks they're a bunch of crooks and they don't abide by the law, but I'm telling you, they abide by trust law. The U.S. Supreme Court follows trust law to the letter. You really understand the Supreme Court and the Constitution, it's all trust law. All right. And one thing I would ask you to either write down or
hold on.
Do I put my name?
I don't know.
nobody's talking.
It came up with just my system. What must verify
Can
my
you mute
system,
them? I can hear somebody. Okay. So write this down and memorize it. He who creates controls. All right. So he who creates the trust controls the trust, which usually means, and I'll get into the diagram, they're the creator, grantor, and then the trustee. Trustee is controlling interest or legal title to a trust. Now, we'll get into the trust diagram in a second, but again, I want to bring up recent events and try to apply them again to this trust law that I'm talking about. So you got the recent events of Chase Allen in Utah, State National, doesn't have plates on, gets pulled over, and then he gets shot dead. Then this week, David Straight gets arrested, and his wife Bonnie also gets arrested. David gets arrested for the same thing, no plates, no registration, no insurance. They seize his truck. Yes, they let him out later, but the point was they still pulled him over, they still arrested him, and they still seized his truck. Bonnie, I believe, had some kind of outstanding, I assume it was a federal warrant, so her situation was a little bit different. But both of them were pulled over for basically the same thing. And I know David preaches or teaches you to tell you to run around without plates on your car. I'm going to beg you today not to ever do that, because according to trust law, you can't. Okay, and you're in dishonor doing it in the first place, and I'll try to explain that as we go. All right. When the police did pull them over, you have to understand that originally when the car was first registered, whoever was the first buyer registered the car with the state. Thus, the state put the car title into a trust. They kept the legal title. They gave the possession of the car to the person that purchased it. Okay. So David and Chase has a use of possession of the car, but the controlling interest or legal title is usually held by the state. So when a cop comes up behind you, normally, if the plates are there, he runs the plates first. Why? To make sure the plates are in the system. Once he knows the plate is the state's car, then he has the right to pull you over. But he also pulled these guys over under the presumption, that the car was the state's property. So do not operate your vehicle without registration or plates. I'm just telling you, under trust law, you can't do it, and you shouldn't do it. So I did a handout. I'm going to go over this diagram right here. This is the basic diagram I created that is a visualization of a trust agreement. Now, almost everything is a trust in today's world, right? The money you use, a bank account, a driver's license, car insurance, life insurance, IRA account, everything is a trust agreement. Okay, by contract, all trusts are contracts. Now, when you're on the internet, let's say you're purchasing something, I don't care if it's on eBay or Amazon, and you click, I agree with the terms and conditions, that's a trust agreement. Okay, because you're the user, you're the beneficiary, you're applying for a benefit, you want possession of it. But, the creator of Amazon also controls Amazon, all right? They're the creator and the trustee both. You're just the beneficiary. So I'm going to just describe these definitions to you. You just look at your diagram. I make it into a triangle. If you ever watch the elite on TV, they always do this symbol. It's the triangle. Trust as a symbol of a triangle. That's the controlling mechanism they have over us and have used for thousands of years, our trust agreement. Okay, way back when the kings ran everything, they called it divided title, whereas the king laid claim to the land by divine right, right? Well, they still called it divided title. He would keep the legal or controlling interest in the property, but he would allow people to work the land, okay, have possession of the land, all right, which means you're the beneficiary of the trust, all right? But if you agreed to do that, a beneficiary of a trust, besides having possession of the asset, also has duties and obligations. So the people that were awarded the land also had to give a percent of the crops to the king, had to pay taxes to the king, and also them and their sons had to fight for the king in the wars. This was the trust agreement if you agreed to take possession of the land. Okay, just like in Game of Thrones, Lord of the North and all these guys, all of these lands are granted. That's the key word, granted to him. They're given a title. The title is Lord of the North, but in that title, okay, comes the beneficiary position, but also comes the duties and obligations. So a trust, what is a trust? A trust splits the title of the asset into legal title and equitable title. Equitable title is the beneficiary, the guy who has use and possession, like a car. When the state created a trust when it was registered, you, the purchaser, got use and possession of the car, so you're the beneficiary. Now, another word for beneficiary in trust law is called owner, okay? Whereas the state maintained control of the vehicle and had legal title to it, they're considered the trustee. All right, that's one of the easiest examples I can give of a trust. And then another one I'm going to give, is a dollar bill. Okay. Everybody's got one of these in their pocket, but whose is it? Okay. Well, it's not yours. I know you think it's yours, but it's not yours. It's in your possession and you have use of it. Okay. which means you're the beneficiary of the trust that's going on. Right at the top says Federal Reserve note. So who do you think created it? Federal Reserve did. That means it's their note. They may have controlling interest over it. And how can I prove that? And how can I prove this is a trust? Because right in front of your very eyes today, the Federal Reserve is changing the purchasing power of the dollar. That's what the inflation is all about. They're devaluing the dollar. You have no control over it, right? Because you didn't create it. He who creates controls. Usually the creator is also the trustee or assigns whoever the trustee is going to be. You, if it's in your possession, you're the beneficiary. You have use of it, and that's all. What certain duties and obligations, like if you use this, you're taxed on it and that kind of thing. Okay. So again, I want to stress that almost everything you do in the commercial world today is a trust agreement. You know, not everything, but almost everything is. All right. A car insurance policy. You're the beneficiary of that car insurance policy, because if you get in a wreck and hit someone, you're not the one negotiating the settlement. You gave that right, the controlling interest, over to the insurance company. They're the one that handles it for you. Okay. So you have voluntarily entered into a trust agreement where you are the beneficiary, and all of these things, you volunteer for this. All right. But and this is how the government controls us, even to this day, is normally they're the trustee. And that's why they're in control of everything. And that's why if you wonder why you aren't, it's always because you volunteer to be in a trust agreement. Usually unwittingly, unknowingly, or deceptively, but it's still a contract, is still an agreement until you rebut that agreement. Okay. So let me read some more stuff. Grantor is the creator of the trust and is the party that makes the offer to contract. He or the settlor furnishes the consideration and transfers the property into a trust. In other words, you're just called a different title, settlor, if you're the one bringing in the consideration or you're exchanging certain value in and out of the trust. But you're sitting at the top of the triangle because you have capital interest into the trust. The grantor specifies the terms of the contract, the indenture, the type of law, which governs the conduct of the trustee, the privileges and benefits of the duties and obligations of the beneficiary. Now, this is again, you got to write this down. This is the most important part of what happens when you enter into a trust agreement. When you agree to be a party of that trust, you're agreeing to be under the law form of the jurisdiction of that trust. Well, who gets to set the jurisdiction or the law that you're a party to inside of that trust? Well, the creator did, the creator grantor. So when, like an example, the state again took control of the car, okay, they said, well, we're going to be under statutory, UCC, or maritime, or Roman civil law. I use those all as synonyms. But then they can say, well, now you got to have it registered, now you got to have plates, and now you got to have insurance. Okay, it gives them the legal right to do this. Okay, that's why it's not your car, it's their car. Okay, you are the owner, which means you have use and possession. They have ownership. The owner is the beneficiary, ownership is the trustee. Ownership means they have legal and controlling interest in the asset or in the thing. Okay, it's not your car. I don't care whether you bought it or not, it's not yours. Now, the other thing, I might as well say it now, is when you purchased the car, you used Federal Reserve notes. And a Federal Reserve note is an IOU. It might as well be a monopoly. Okay, it wasn't real money. Okay, so when they took away the real money from us, they put everything, all property into trust, well, specifically so the legal title can't pass. So you don't deserve the legal title because you didn't pay for it. You just discharged it off to somebody else. You just gave them an IOU that says somebody else will pay somewhere down the line. That's not honorable. Okay, so I know you think and are led to believe it's your car because you paid for it with Federal Reserve notes. I'm telling you, you're not. It's phony. It's an IOU. That might as well be monopoly money. The legal title never passed. It's not legally your car. All you do is get use and possession, or the right to use the car. And when you sell the car, that's all you're selling, is the right to use the car to the next person. Okay, You can't sell something you don't have. Okay, and if you don't have legal title, then you can't pass the legal title to the next person because you never had it in the first place. The state maintains it. And why does the state maintain the legal titles? Why is all of this done? It's all done because they take that legal title, that piece of paper, they batch them together, 10,000 of them in together, then they give them to the bank as collateral so they can borrow money to run the government. Okay, so the titles, the legal titles to the property, whether it's a car, a house, or anything else, a driver's license, the state and the governments use that as collateral because it's a paper asset. Okay. And in banking, that's an asset they can put as a tier 1 deposit, thus allowing them to lend out 10 to 30 times the amount that those pieces of paper are worth. Okay. So the whole function of these trust agreements is to run the government. It has for the past 90 some odd years. This is the reason why all of this is being done. Okay. Go on to the next thing. The trustee holds legal title to the trust assets. He is the one to whom the offer is made. The trustee, also called the fiduciary, carries out the conditions of the trust contract and is the protector for the property placed in the trust. He or she pays and settles all accounts or charges against the trust. I must say that again. He or she pays and or settles all accounts or charges against the trust. So in a court of law, when they're making a charge on your estate trust, okay, the judge, supposedly being a unbiased party, needs to find two people. He needs to know who the trustee is and he needs to know who the beneficiary is. Okay. But the more important one, he's looking for the trustee because the trustee is the one that settles the charges against the trust. So the first thing he always wants to do is to find out who the trustee is. And another word for trustee is defendant, if you look at my diagram. So when he calls your case, it says, Mr. Anderson, are you here? Are you Mr. Anderson? What he's asking you is, are you the trustee for the Mr. Anderson trust I have here in front of me? Because he's looking for the guy to talk to who's going to settle this up. And if you say the word yes, you've just said, I'm the trustee, I will take care of it, I will pay, and I'm guilty. That's how fast it's over. Okay. But if you rebut that presumption by saying, no, I'm the grantor beneficiary, and as grantor, I have the power to appoint a trustee in this trust, I therefore appoint the court as trustee. Okay, that just flipped the positions of the trust. Okay, where now you're sitting in the party that's supposed to receive the money, and you appointed, and you had the power to appoint only by declaring yourself the grantor. See, all of these positions, whether you're the grantor, trustee, beneficiary, have certain powers to it. Okay, as the beneficiary, I can't appoint a trustee, and as a trustee, of course, I don't have the power to do that either. Only the grantor. So you got to know which party in the trust has the power to do what things. Okay. So always remember that the defendant is another name for trustee. And the trustee in the public, and all of these public trusts, are the liable party. You volunteered. If you volunteer to be the trustee, then you're volunteering to pay. Okay, we call that surety. A surety is by Black's law, a person that agrees or volunteers to take on the debt or obligation of another. Okay, so when I use the word suretyship or trusteeship, I'm using them in almost a synonymous term. But of course, they get you to volunteer for this. You're actually the beneficiary of all these trusts, but when they stick a piece of paper in front of you or they ask you what your name is, you're volunteering to be the trustee, surety. Okay, that's how the contract is done. It's implied. Okay. Next one, beneficiary, holds equitable title. He gets use and possession of the property in the trust. He's the beneficial owner, gets privileges and benefits, but has duties and obligations to the trust. So let's, if anybody, just for fun, as a practice session, get out a piece of paper, draw a triangle on a piece of paper, half the size of the paper. Let me see if I can find it. All right, you didn't get this, but I'm going to just try to take you through one. Okay. The 1789 Constitutional Trust, drawn as a triangle. At the top, who was the creator of the Constitutional Trust in 1789? The 13 original states. Okay. They got the power from we the people, but we gave them, they're the ones that hired a company called the United States to do the 19 enumerated powers. So they hired the trustees of the 1789 original trust was a company called the United States. And who's the beneficiary of this great document that our founding fathers created? Well, it was we the people and the posterity. So we the people and the posterity were meant to benefit from the original 1789 constitutional trust. Okay. And inside that trust, any party that wants to claim to be a party to the trust, which I do, I claim I'm one of we the people and the posterity. Thus, I want to be under the Constitution and the Bill of Rights, because that was the law form. Also, common law, actually common law, equity, Constitution, and the Bill of Rights were all in the law form that was created in 1789. I want to be a party to that trust. I want to lay claim that I'm a party to that trust. Okay. I do not call myself a state national under U.S. code. I call myself a beneficiary of the 1789 constitutional trust, and that's what gives me the right to make that claim as beneficiary and to have those privileges and benefits like the Bill of Rights, okay, like equity law. All right, and that's going to be in converse to the, let's call it the 1871 trust, constitutional trust. Another trust was created when they formed the District of Columbia. I think everyone knows that when they incorporated themselves. But another trust was created by the parties that were involved, okay? And in that trust, you're not the beneficiary. You're actually were appointed, U.S. citizens or citizens of the United States were appointed as trustees, whereas the governments claim to be the beneficiaries. They're the ones that created it, okay? They got together, the trustees. The original trustees of the constitutional trust got together with the corporation and convised and made up this trust to try to alleviate all of the states that were bankrupt and were out of money. Basically, what they did was they came in and said, hey, we'll come in and start paying a lot of these bills. We'll pay for all of your employees, all your government employees in the state. But to do that, you got to enter in this trust. So you got to sign on the dotted line. Okay. So then again, they got entered into a different trust with different benefits, different duties, different law form. Okay. But this is how it's always done. Carrot on the stick, the benefit is dangled in front of everybody. And if you take it, you're entering into that trust agreement, you're entering under that jurisdiction, under that law form. Okay. I'm just trying to make sense of it to you so you can understand how all of this either pertains to you or how all of this is going on. All right. One more example. Let's do birth certificate. Now I'm going to use the state one, okay? Because there's two birth certificates. I have a podcast for 2 hours that covers the differences between the two birth certificates. One, of course, is done at the county level, and the county certificate of live birth is actually the evidence that you're a Union State citizen. Okay, if you get that double authenticated, signed by 2 more government witnesses, that is proof you can bring into a court of law to prove your Union State citizenship. The state created birth certificate, which they call the birth certificate, by the way, not certificate of live birth, is where the straw man is created. Okay. So he who creates controls. I'll say this over and over again. The state created state birth certificate. So they're the creator and the trustee. You're the beneficiary. How do I know that? Well, because it's in your possession. You have use of it and it's in your possession, which is again proof that there's a trust going on. Okay. This is very important to understand. Now, what it really means is the name on the birth certificate that you were granted, not given, granted, the use and possession of the all caps name. Okay. So the whole reason the straw man trust was created was for your benefit. So you could play the game of commerce. Okay. Because everything in the commercial world is artificial. And of all honest people should know that artificial people cannot interact with natural people. Okay. So they created a trust for your benefit by creating the straw man so you could use that name in commerce to do commerce, to make money, to get a job, to have a car, to get car insurance, life insurance. Okay. It's the evidence that you have use and possession of the name, but you're not liable for it. really they're liable for it. But of course, what happens all the time is they stick another piece of paper in front of you, like the driver's license application. Oh, would you just sign? Would you volunteer to be the trustee in this trust, not the beneficiary? Okay, so this is how they switch the roles between trustee and beneficiary all the time. And also, I think one of my podcasts, I think in the Congressional Record, there's actually someone quoting that you're a co-beneficiary and co-trustee of the Public Charitable Trust, which is the trust that was created in 1871. Okay, so you could be either one. All right, by choice. Everything in this country and everything in this world, by God, you were given free will. Okay, you have by choice whether you want to be the trustee, whether you want to be the beneficiary. You have by free choice whether to be a Republican or a Democrat. You have free choice whether you want to be a Union State citizen or a U.S. citizen. These are choices which you either volunteer or claim to be. Okay, I'm just telling you, there's legally, lawfully, everywhere around it, they're going to give you, by trust law, they're going to give you the chance to claim which one you want to be. They're going to try to trick you into volunteering to be the one you don't want to be, but you have to keep making the claim, you know, that you're the beneficiary in all of these public trusts. Okay, so you get use and possession of the name. It's not yours. You don't have control of it. Okay, and also they put a trust on your upper lowercase name. All right, that's in the county. All right, so you have use and possession of your upper lowercase name when you're a child, right? You use it in school, you use it later, but who really has control of that? They've made a claim on it. In other words, the original claim to the name comes from this. Again, this is back in my other podcast. When the after you're born, when the real baby is born and granted the name by the parents, okay, that's called a claim by nature, because your natural parents granted you that name, and you actually have the higher right by nature to the name than they do. Now, when the placenta and the afterbirth come through, they consider that abandoned property. They presume it to be abandoned. Okay, but it's born alive. It's got your DNA in it, so it's given your all caps name when it dies shortly thereafter. Okay, and then that name is placed in trust, and this is the evidence of that trust. Okay, but their claim is what's called by legal characteristic, because it's based on abandoned property. Okay, now I'm sure you guys have ever read or seen on the news where some diver off the coast of Florida, whatever, they find a treasure chest full of gold coins. Okay, well, it's not finders keepers. Okay, you can make the claim because it's in your possession, it's yours. But if they're Spanish doubloons and they have a mark on there from 1492 or wherever, then Spain's going to come along and say, no, our claim is higher because we're the ones that created that money. And almost always, as far as I've ever followed any case, is the money that's found like that is awarded to, like Spain, whoever had the legal claim on it, who could prove the legal claim. Now, do they give something to the person that found it? Yes. Okay, so he does get a share of it. But my point is this: you have to know who has the higher claim by trust law, and a claim by nature is higher than a claim by legal characteristic. So your claim, when you finally make it to the name, will overrule their claim that they're in the superior position. And this would apply to even court cases or anything else. Okay, so again, it's all got to do with trust law. All right, let's move on to, I gotta find it, 14th Amendment. There it is. Because there's a lot of confusion always about the 14th Amendment. And again, I'm going to show you how this all applies into trust law. 14th Amendment, Section 1. All persons born or naturalized in the United States. And here, the United States, you have to assume meant the United States of America. All right. Whoever was in the Union, because the United States Corporation wasn't formed yet until 1871. And this is in 1868. It's 3 years prior. Are citizens of the United States and of the state wherein they reside. Okay, so the key wording is and of the state wherein they reside. So if you look at the U.S. Supreme Court decisions, which I'm going to name a couple here, there's two types of citizenships. Which one do you want to claim? Do you want to be a citizen of the United States, or do you want to be a Union State citizen, or what they say, a state wherein they reside. Okay, I call it Union State citizen. Now, 2 years or 1875, United States versus Cruikshank, U.S. Supreme Court. We have in our political system a government of the United States and a government of each of the several states. Each one of these governments is distinct from one another, and each has citizens of its own. Okay, so each one has citizens. Okay, American citizen or a Union State citizen, citizen of the United States. 2 different trusts now. Okay, which citizen really means beneficiary. So if you're a citizen of one of these trusts, which trust are you going to lay claim to that you're a citizen of? Okay, 1789 trust or the 1871 trust? 1883. This is McDonald v. Jordan. One may be a citizen of a state and yet not a citizen of the United States. Again, it's telling you that there's 2 different jurisdictions going on, 2 different citizenships going on. There's 2 different citizenships. There's got to be 2 different trusts going on. And of course, if there's 2 different jurisdictions, there has to be 2 different trusts, 2 different parties to a trust. All right. So you got to know what trust you're in to know what jurisdiction you're in. How do you know that? Well, which one are you claiming to be? Which one are you claiming to be? Okay. If you're claiming to be a state national that's defined under 8 U.S.C. 1101-21A, you're under the 1871 statutory maritime Roman civil law jurisdiction. If you start claiming you're a beneficiary of the Constitution and you want to we the people and the posterity, that would put you in the 1789 trust where the Constitution and the Bill of Rights are. Okay, do you see the difference? There's a difference in what you say to them and how they're going to interpret who you're standing under or what trust you're a party to. Because that's really what you got to do is start claiming which party you're a trust to. Okay. All right. Now I don't think Anna does this, but I try to find her. I don't really have her recent stuff. But David does this affidavit of repudiation where I think they repudiate the 14th Amendment citizenship. So if you repudiate and use the word 14th Amendment citizen, you've just repudiated. First of all, I don't think it works, but if let's say it does work, you repudiated both citizenships. So you just gave away the good one. Yeah, that was the bad one, but you didn't distinguish the specific citizenship you were repudiating, which is really the public citizen of the United States citizenship, not the Union State citizenship. Okay. So I think that's a big issue. I can't again remember if she does that or not. So just look at the wording when you do this. I think it's okay to repudiate U.S. citizenship because you were never the U.S. citizen in the first place. Okay. The straw man is the U.S. citizen. Okay. The legal entity, the piece of paper is the U.S. citizen. It's just a matter of, do you want to volunteer to be surety for that thing, that U.S. citizen? Okay. So when you check that box, I'm a U.S. citizen, that's what you're doing. You're saying that you're going to be the surety or trustee for that. You're going to be liable. Okay. They gave you the choice. They gave you free will. You had the choice to say no. You didn't have to. See, their viewpoint is because you were too dumb, it's not their fault. Okay. Ignorance of law is no excuse. That's what they always say. Right. A beneficiary, when he applies for benefits of a trust, is supposed to know the details of the trust agreement. All right. This is how they get away and don't go to jail, is because really the onus is upon you to know what you're doing. Now, is that really what I say lawful? No, because it's fraudulent on its face. It can be undone. It can be rebutted. Okay. But I just want you to know that you always have a choice on what you're declaring, what citizenship you're declaring. So be careful the definitions you're using to rebut their presumption of a U.S. citizenship. Okay. And again, U.S. citizenship means, of course, they control it. Of course they do. The U.S. citizen is a party, a beneficiary to that 1871 trust. All right. Now, if you were, let's just say again, if you disclaimed your 14th Amendment under the military occupation, and again, that's why I sent you that stuff on the military occupation. There's three designations under military occupation. You're either an enemy, a neutral, or a friendly. Okay. And a neutral is treated as if they were an enemy. So there's really only two. You're either an enemy or you're friendly. All right. And a stateless, under the definition under the Lieber Code, is considered a neutral. So you'd still be considered an enemy of the state, which is a U.S. citizen. Only the friendlies, which would be your Union State citizens, okay, that would be considered, I'll use the word free or not under their jurisdiction. They're not going to bother you. They have no right to seize you or your property if you're considered a friendly in the military occupation. Now, how do you get a security clearance? How do they do that? Well, it's your passport, okay? Your passport card has above, upper left-hand corner, above your surname is usually 3, 4, or 5 stars on it. That's a security clearance. Okay, I consider it like a military security clearance. U.S. citizens have 3 stars. Okay, so if you're a 3-star, you're kind of considered the same whether you're a neutral or a U.S. citizen. You're still considered an enemy of the state. If you can get a 4 or 5 star above your surname on a passport card, that means you're a friendly. That means that is an evidence of the indication that they look at you as a non-U.S. citizen. Okay, so do I think it's important to get one of those? Yes, it's not the end of the day if you don't, because it's all on how you apply. If you still apply and mark you're not a U.S. citizen, the boxes, it'll still work, but at least that's something you can have in your hand if things ever got worse, or let's say China came in and occupied us. You would have something that could protect you, is to look at that you're not an enemy of the occupying force. Okay. Now, in the paperwork too, it goes from the 7 transitions from when everyone was a what we call an Article 4, Section 2 Union State citizen, and how that citizenship was changed, okay, through the 14th Amendment. You know, there was another one that was put in there. Now you have 2. Now the Supreme Court cases, it all depends on how you come forth to the Supreme Court. In the classic examples everybody uses are the slaughterhouse cases. All right, the slaughterhouse cases made a claim that they were being denied the due process of the 14th Amendment citizenship. So I put them in this certain category, a certain designation where they didn't have the Bill of Rights. So the Supreme Court ruled in the slaughterhouse cases that they didn't have the Bill of Rights because their claim was coming from, I'm a citizen of the 14th Amendment and I was denied my due process. Okay. So again, in the handout that I just give it to everybody that reads. This actually was written by Eric John Phelps. It just shows you how everything was done in terms of the transitioning of the citizenship. Once the 14th Amendment, what I call public citizen of the United States, really a piece of paper. It's not you. Again, you just claim to be it. That citizen of the United States, okay, becomes the straw man, okay? And then the straw man, when he applies for benefits, or your mom does for you, and the Social Security, then you become, that new person becomes a U.S. citizen, okay? So the public citizen of the United States of the 14th, to me, is artificial person citizenship. The U.S. citizenship is obviously a piece of paper, artificial citizenship. The real man is the Union State citizen, always has been, always will be. Unless you volunteer and waive your rights, okay, they're not. It's another thing I don't like when people say they were stolen. They didn't steal anything from you. You voluntarily waived them. Rights cannot be stolen. You cannot give them away. They can only be surrendered or waived, okay, by you. Now I'm going to read the case. This is another U.S. Supreme Court case, 1906, Hale versus Henkel. This is the most quoted case in the history of our country. Almost 2,000 times this case has been cited. There's a reason for this. I'm going to read it to you. Quote, the court rules there is a distinction between private natural persons and artificial persons. Here's the quote. The right of the individuals are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agencies of government. So it's telling you the rights of the individuals, the Union State citizens, are restricted only to the extent that they have been voluntarily surrendered. Okay? It's telling you right in front of your face, you have to volunteer and waive your rights. Nobody's taken them, no one stole them. You waived them. How did you waive them? By entering a trust agreement, not unknowingly, unwittingly, deceivedly. Now, again, I teach my students that because this was done under the color of law, under fraud, it can be undone legally. Okay, because the statutes of limitations on fraud never disappear. Okay, so even though you might have done all of these stupid things, deceptively been signed in the contract, you can undo those contracts, undo those signatures by law, by their own law. Okay, it can be done. All right, I just want to let you know that it's really, I always use the phrase, pick up the mirror and look, and look at it. You're the problem and you're the solution. You got yourself into this mess one by one by the birth certificate. It was done one by one. It wasn't done by this massive movement, but you could undo it. But you have to, right now, under the system, you have to undo it one by one. So only you can undo it. There is one other way. Of course, the President of the United States can rescind Proclamation 24, which would put us back in the Republic. But right now, everyone is operating in the commercial world, whether you're a private citizen or not, you're operating in the commercial world, which is their sandbox and their jurisdiction. So you have to know how to operate safely within that jurisdiction. Okay. So let me do a couple things here. And it's the second. This, you need to commit to memory. You need to be able to visualize this in your head of the diagram. First thing you always ask yourself when you're being made an offer, am I going to be the trustee or am I going to be the beneficiary? You got to know what position on the trust you are. And then you also got to figure out, well, if I'm signing this with Amazon, what law form are they using? Well, it's probably UCC or Roman civil law. Okay. Which means you put yourself under their jurisdiction for that contract of what you're buying. Now, what you didn't know is that you can amend that contract or change that contract. In other words, nothing prevents you from picking up a piece of paper, writing a notice, in equity, we call it notice, and telling them, I signed this, I had to check this terms of, I had to agree to the terms and conditions. There wasn't a place I couldn't, so I hereby reserve all my rights. That's all you got to say. And that just amended, counteroffered their claim and gave you your rights back. Okay, but you didn't know you had the power, did you? Okay. The analogy that I use is always about the Wizard of Oz and Dorothy at the end of the movie. She misses the ride with the professor, the wizard, to go back to Kansas. And she thinks it's all over. Then the good witch of the north or whatever comes in and she says, Dorothy, you always had the power. You just never knew you had it. All you had to do is click your heels 3 times and there you go. So she clicks her heels 3 times and bam, she's back to Kansas. So what I'm trying to tell you is you have the power to change this. You have the power to amend their contracts anytime you want. Okay. I'll give you one quick example. Whenever my wife and I go on trips or cruises, she buys them months in advance. Well, if something happened to me, and I couldn't go, right in there, it says, non-refundable ticket. I agree to all terms and conditions, right? Well, I write a letter right away to the airline company or the cruise company and say, well, I'm just reserving all my rights. So twice in my life, this has happened in 20 years where somebody's gotten sick or I've gotten sick or I couldn't make it. And then I'll write to the company and they'll say, well, our policy says that it's non-refundable. We're not going to do it. And we did receive your letter back at such and such. And in your case, we're going to go ahead and refund the money. Okay. So that's how these things kind of work. You have the ability to counteroffer, amend, or another word in the SPC world would be conditionally accept. I conditionally accept your offer upon da 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 da. Okay. So you have the power to do all of these things. I'm just telling you that. You don't have to be stuck with it. It doesn't have to be this right and left, one or the other. You can actually work within their system by their rules and still maintain your rights. Okay, but the only way you have rights in their C jurisdiction, statutory jurisdiction, is to claim you're a beneficiary of a trust. Because only the beneficiary of the trust has rights. Okay, so that's why I'm always about this trust law, understanding you're the beneficiary and always coming forth that I, as beneficiary, hereby claim this, not I, John Doe, claim this, because I, John Doe, the presumption is you're acting as trustee. And as trustee, you can't, I'll give an example again. David says, I demand refund of the Social Security Trust Fund account. Well, what right does he have to that account? I'm going to tell you, he has no right, okay, because he who creates controls, the government created it, they controlled it for the benefit of the straw man. So nowhere in any of those three parties is the real man. So if you come forward as the real man, you don't have the power to claim anything. You only have the power as being surety to the beneficiary position to make a claim on the Social Security Trust. Do you understand what I'm talking about? This is what trust law is about. Using the proper term, making the proper claim, knowing you have the proper title. Okay? So that would bring me into the rollover of the title and the powers of a grantor. Now, David and Anna both do this deed of reconveyance. Let me get there around here so I can see it. So I've got David's and I've got Anna's. Now, David's is called deed of full reconveyance. Okay, I do hereby claim the entire estate. Who's I? He can't claim it. Who is he? He's not declaring himself what party the trustee is. And I, as David Straight the man, has no claim on the trust. Only the beneficiary's claim on the trust. Okay. He also wants to include the minor account. Minor account was not set up for him. He didn't create it. He doesn't control it. He can't. So these claims are almost null and void on their face. Now, the part about the deed of reconveyances I wanted to get to you guys was trust law states when you're, well, what are you reconveying? Okay, so let's go back to the document itself that you or he creates. Reconvey. What are you reconveying? Well, you're trying to reconvey the rights, titles, and interests, the legal rights and titles and interests to certain property. Okay. But trust law says to convey a legal title, you have to have valuable consideration. Okay? And valuable consideration under trust law means lawful species of money, which means gold, silver, a stamp, or a money order, because stamps and money orders are backed by gold, partially backed by gold. So they're considered lawful money. They can be used in the public, but they're still considered lawful money. FRNs are obviously just public debt money. Okay. In order to move a legal title, to transfer it, to convey it, you have to put legal or valuable consideration on the contract, on the deed. Okay. Because legal title cannot pass without lawful species. So there's nowhere I see of a stamp, a coin, a money order on any of these deeds of reconveyances. Okay, now let's read Anna's. I reconvey my given lawful trade name. You can't convey it. You can't do it because there's no valuable consideration, and you need a deed. You need a deed of reconveyance with valuable consideration. Then you also need a deed of acceptance into the trust, which has a valuable consideration on it. Now let me read you. This is right out of Gibson, which is the godfather of law books for trust and equity. Until a deed is accepted by the grantee. So in other words, you have to say, once you convey it to only a grantor, not I, only a grantor gets to convey, has the power to convey. So you have to claim you're the grantor, all right? The grantor, and then conveys it to another person, which is the grantee. So they're going to grant over both titles, and then you've got somebody on the other end on another trust that's going to accept both titles. That's called the grantee position. Okay. And only a grantee can accept both titles. Okay. So until a deed is accepted by the grantee, the title to the estate does not pass out of the grantor. So that means it never moved. For no man can make another his grantee without his consent, and a deed made to a man with all requisite formalities, even entered into the public registry, will be null if not afterwards accepted by the grantee. That's called an equity maxim. Equity will not aid a volunteer. Equity will not complete an imperfect gift. So the title is imperfect because it doesn't have legal title. Okay. So you cannot one, convey, and two, accept, and you got to accept it into another trust, the legal titles to what you're claiming. Okay, now I'm gonna flip that on its head and I'm gonna reverse it. So when you're buying a car, right? Remember, purchasing a car. I'm not sure what word you want to use with IOUs on the contract, to whether you paid cash or whether you borrowed money. Was there any lawful species of money on the contract? Was there a gold coin, silver coin, dollar stamp, or a money order attached? No. So what does that tell you? That means the legal title never passed over to you when you accepted the car. Okay, by law, by legal and lawful, the legal title never passed. In legal land, in their jurisdiction, in the C jurisdiction, they concede and they will allow the legal title to move when there's valuable consideration. That's why you can get the legal title to your house. You can, I don't, advise getting the legal title to your car, but you can get allodial titles. But you have to do it with deeds of conveyance and deeds of acceptance, and they both have to have valuable consideration on them. Otherwise, it's null and void. Your claim is worthless. Okay? This is all not me saying it. This is trust law saying it. And trust law is the highest form of law on the planet. Okay? I just follow trust law. I'm going to open it up now for questions, or if anybody's got comments. I've covered most of the stuff, but I'm sure people might have questions. Now, I don't mean to bash everybody. I'm just trying to tell you where I think, and in my opinion, the faults are. Okay.
So anybody that has a question, just unmute yourself and ask Tom a question.
Hey, Tom, I've got a question for you. This is Don.
All right.
Your process is largely at least premised off of getting your birth certificate authenticated twice. What about for people that have emigrated to the States and they don't have that? They just have a naturalization form.
Yes.
Is the process different for them?
You can only get something authenticated if you were born in one of your birth state. Then your Secretary of State at your birth state will authenticate it, and then they can send that to the State Department. The certificate of naturalization is it. There is no authentication process to that. If you have the original certificate, not a copy, if you have the original certificate, then you're under section or 14th Amendment, section 1, and you're treated as if you're on equal footing with someone who was born in one of the Union states. So you don't need, and you cannot authenticate a naturalization certificate, and you can't certify that either. That's as good as it's going to get. Okay, so the good news is when I run into people that were either born in DC, which have that same type of designation, or a naturalized citizen, it cuts about 2 months off the process because you don't have to go through the whole authentication process. So we still use it, and the wording is different in the claim, of course. We got to really make the claim under the equal footing doctrine, as if we were one of we the people, one of the posterity. Okay.
Okay, so you have a separate set of forms for
Yes,
people.
yes.
Okay, thank you.
Because it has to be, because they're two different entities, two different kind of like citizens. You see what I mean?
Yep.
So we have to have a difference in the paperwork.
Okay, thank you.
It's more custom made to your specific designation. I'll give you another one I run into all the time. I run into children of military members that were born abroad. Okay, they have a special certificate called a birth abroad, a certificate of birth abroad, which puts you in like a naturalization or a DC citizen. And again, it's a different designation, but you can't get that authenticated. You just go with the original document that you get from the State Department. When you come back into this country as a child or an adult, if you've been over in Japan or Germany, you can get that certificate. Okay.
All right, thank you.
There's got to be questions.
I have a question. This is Patricia Ombavard.
Yes.
Back to what you were last said about valuable consideration
Yes.
you must have. on everything then, a allodial title, whether you're in court, like I've seen people go to court and put their gold coins right on the bench before they even start. Allodial title, I'm not sure who you have to pay the gold. That couple times I've heard about going and paying certain things with gold to get your allodial title to
The
make it.
grantor, I don't mean to interrupt you, the grantor is the one that provides the valuable consideration. So if you buy a piece of land from someone and you want a loyal title, the seller would actually have, the grantor who's granting you the title has to put the money on. You could give them the money, but he has to provide the valuable consideration. And then you provide the valuable consideration. Once he grants it the conveyance, then you have to accept the conveyance. Now, I've never heard about bringing gold coins into court. You can make, the easiest way to lay claim to the legal title to the name is to do an adult name change. Then you'll have a judge's decree that says you have the legal title, because that's what they're awarding you. When they do a name change from the all uppercase to the upper lowercase name in court, and you get that decree, that judge granted you the legal title to the name. Now, guess what happens if you want it? You have to do an acceptance. Okay, as grantee absolute, then get that as a matter of public record. So you have to show how the title moves. You have to have evidence of the title moving from one entity to another. And if you're claiming you have it, you better have evidence that you can provide in a court of law that you actually have the legal title. You just can't verbally claim it. You physically have the evidence with deeds of conveyance and deeds of acceptances. Does that make sense? Patricia?
Yeah, somebody was talking in the background. I'm sorry. Yeah, some of it, they overrode you, but the other thing was with the documentation that we do with Anna, and you say there's no stamp or anything on it. Does
Correct.
that makes those all more valid if we put some kind of stamp, not just our thumbprint, but a stamp on it?
Please, 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 please put a dollar stamp on it.
Okay,
Before it's recorded. You want the evidence is that it was recorded with the valuable consideration on it. Do you see?
yes, I do. I yield. Thank you.
Then the judge will accept it. Then the government will accept it, because now you've done it according to trust law. You've done the requirements. Okay? I know it sounds small, slight, but it's a huge difference in when you're making claims to understand trust law, to that you have to do this kind of stuff. If you want to put your guns into a trust, you have legal title and equitable title to your guns. You better be using some stamps, because once you can get your guns into your trust, then the government can't seize private property that's in a private trust. You see how important now these kinds of things can be if you have evidence. Let's say the cops raided your house, stole your guns. If you had a deed of conveyance and acceptance, you could walk right back to the judge the next day and he'd give you that property back inside of 30 minutes, or somebody's going to jail. Okay, but you have to be able to provide evidence that it belongs to a trust, not you. You're just the beneficiary. Okay, it belongs to a trust, thus it's private trust property, thus you got to give it back. Put it back in my possession. Okay, if you say, if a cop knocks on your door and say, that's my gun, well, he's going to take it because he's assuming you're acting on the strong man. Okay, but if you say, no, none of those weapons are mine, they all belong to a private trust, he probably is not going to take them in the first place. Okay, if a police officer pulls me over, is this your car? Oh, no, 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 no. It's not mine. It belongs to a private trust. Okay, he wants you to say yes so he can make that joiner and make that ticket. You see, again, I'm just trying to give these little things how they can play a big difference in when you get stopped, when the police might take something from you, if you ever want to get your property back and make the right claim that it's yours, or you make it through, you're the beneficiary of these trusts. That's why it belongs in your possession. They recognize trust. They recognize beneficiaries of a trust. And in their courtrooms, all trust disputes have to be settled in equity. Okay. Wow, that's a different jurisdiction. Okay, so if you can get them to see the trust, acknowledge the trust, then you get to be in front of an Article 3 judge it's going to handle it with trust law instead of statutory law. That's how you change jurisdictions in their courtrooms, is you make the argument about a trust property. And you have to be claiming you're the beneficiary of the trust. Okay. Next.
Hey, Tom, I have a quick question. If you have a home that is inside of the trust, okay, and it goes into foreclosure, can the home be taken over through foreclosure if it resides
Depends on the
within?
trust. Is it a public trust or private trust?
It'd be a pure trust, like you do.
Okay, well, then no. See, in trust law, and I'm gonna say it might be a little confusing, the beneficiary is the true owner, which means the beneficiary really has the equitable and legal title if you can prove it. If you can prove you're the beneficiary, you actually you have the allodial title in trust law. Okay.
Oh, really? So if your home is within the trust, getting the allodial title is maybe not necessary? Would you say that, or?
Correct. In a way, I would say that's correct.
Okay, well, thank you. I yield.
Now, if you're still paying on it, then somebody's got an outside claim on it. You would have had the property paid off. I'll just add that as the last thing on the other one. If you want to make the claim that you have a allodial title to the land that the house is on, not the house,
Right,
and
right.
the land and its fixtures is what you're laying claim to. That's why the land patent from the BLM, it's the land and everything above it and below it is yours. Okay.
Right.
But you gotta have it paid off, even with debt notes, to make that claim. Otherwise, someone else really does have a claim because it isn't paid off yet.
Okay, so if you have a mortgage still on it, and they can get to it inside the trust. Okay,
Right. But we actually, catch up with me in 6 months. We're working on a system to actually lay claim to that original mortgage, which would get you on what we call an equitable redemption of a mortgage, which you have by right, by birthright. If you claim you're a beneficiary of the 1789 Constitution, you can get your mortgage back.
well, that sounds good.
Yes.
Okay,
Next.
so to be clear, if you have a home, you have a mortgage, and it's in foreclosure, by transferring it into a trust is not going to stop the foreclosure or prevent it from being taken from you.
So what title to the house do you have? This is a quiz. What title do you have to the house presently?
Equitable only.
Equitable. You have use and possession. That's all you have. You don't have the legal title, do you?
Okay.
Now think of this. Think of the word they're using. They're going to repossess your house. Repossess it. That means they just want possession back. They're not claiming legal title. They're claiming repossession rights under the failure to pay the promissory note. See, they're not even making a claim that they have the legal title because the government's got it. They just want repossession of it. Now, I got to tell you the story. One of my mentors, Rourke, expert at trust law, equity law, he's gotten a couple cases in front of the Supreme Court, absolute genius. He underwent a foreclosure back in 2008, lost his house, went through 2-3 years back and forth, nothing going anywhere. He puts the keys to his house. He's still in possession of the house, of course. Puts the keys of the house in an envelope, sends it to the U.S. Supreme Court, and says, "Would you please return the keys to the rightful owner?" Guess what? Supreme Court put them in an envelope, sent the keys back to him with a 1-page little paragraph. We returned the keys to the rightful beneficial owner. He took that into court. The judge, case dismissed. You see what happens if you do it right. See what happens if you make it from the beneficiary position. Okay. I'm just saying it can be done. The U.S. Supreme Court knows what trust law is. Now, most of the time they're dealing in C jurisdiction. Okay, when you come into a Supreme Court and you do a case, you have to say, what rule are you coming in under? And there's like 48, 49 different rules. And everything up to 48.2 is under the C jurisdiction or territorial jurisdiction, statutory. But rule 48.2 says you're coming into anything but the territory. Well, it doesn't say union, but it says it's not the territory. And there's only two jurisdictions, either the territory or the union. Okay, sea, land. It's synonyms, the same thing. So, you know, you got to be knowledgeable. You got to know the words you're using, the claims you're making. But if you do it under trust law, believe it or not, just like when God set up and created the earth for our benefit, we're beneficiaries of the sacred trust. Everything is really for us, if you know how to do it. Next.
This is Luke.
Hey, Luke.
I have, do you have this information available to study, like in a,
Of course.
like a file or anything like that?
Lots of, I got news for you. It's more than one file.
Well, of course, yes, of course. I haven't put two hands on the wheel as far as the trust law part of it. I mean, I've got one hand on the wheel, and this is definitely going to refine what I'm doing.
Just telling you, it's going to enhance
Yeah.
and expedite your learning and your ability to comprehend the big picture.
Yes.
That's all I'm saying.
Let me just correct me if I'm wrong, or if you have any recommendations. I've done a couple things with some allodial title. So what I did is I bought an F550 a couple years ago, and I built this, really cool off-road camper on it. But when I did, I got the salesman to basically agree to give me the MCO.
Mm-hmm.
So I took the MCO, and I also told them that I was going to give them as payment in lawful specie a silver coin. And what I did is when I went there on the contract I did a wire transfer, and then I wrote with my pen, I put in 1 troy ounce silver.
Right.
And then I made an affidavit or a declaration of fact, noticing what I did.
Mm-hmm.
And then I did a deed of acceptance of title. And then I went and I recorded that at public record.
Did you do the deed of conveyance?
The deed of conveyance, that's the part where
Missing.
I think I'm missing.
I
What I
actually
did is,
believe in my handout, in this handout with the trust diagram.
Yeah.
Is a copy of what I do in notice of conveyance of legal title, just the conveyance. I put an example on how to do a deed of conveyance. I
okay,
didn't do a deed of acceptance, but I did do a deed of conveyance.
okay. I did do a, I mean, I want to see the language in that so I can get it right. And if I have to add that document, then I'll do that.
The concept
But-
is you have to show like a chain of custody. It went from this person, conveyed to this person, and accepted by this person. You have to show the chain of title. The
Yeah.
root title. That's what all title insurance companies do, supposedly, is check those titles. They go back and see how the title was moved and sold forever. Right. So that's
Okay.
just, if you have that, your chances of making those claims go up tremendously.
Yeah, that's about what I did. Is it was kind of just a record. Here's what happened, and I gave negotiable instruments that was produced that represented the value of my labor property that was accepted by Sun State Ford. And then I also addressed the first thing I addressed was the lawful specie of what I paid for it, thus paying for it with lawful money pursuant to Article 1, Section 10.
It's not important what you paid for the car. It's
Right.
It's important that you paid for the title to move. Because that's
Right.
all that's important is the title to the car. You're gonna get possession of it.
Yeah.
You didn't really have to prove that you paid for it with lawful money. You got to prove that you conveyed the title, legal title to the money. That's the important part of all this. Okay.
Yeah. I think that's the last part that I got to confirm if I did
All right, if
correctly.
you want to contact me, it's
Yeah.
mrbeneficiary@gmail.com.
MR or MISTR?
MR
MR beneficiary
@gmail.
Mr. Beneficiary at gmail.com.
That's it. So again, I'm just trying to, and again, I want to teach you the concept.
Yeah.
You have to understand it's the titles are moving all over in commerce, whether they're perfect or imperfect. Okay.
Yeah.
Whether both titles are moving or just the equitable titles moving. That's what these trust agreements are all about. What title is moving? You're
Yep.
all moving, the equitable title is being moved to you, not legal. If you want legal title, you got to do special things that they will recognize. Okay?
Right,
Okay.
right. Thank you very much.
Welcome.
Okay, so I own my car outright. I have the MSO, I have the certificate of title.
Where'd you get the
And
MSO from?
from the dealership.
Okay.
And yeah, so I'm the only one who's owned it. Now, I was about to submit acceptance, deed of reconveyance, deed of conveyance to my estate at the courthouse, but now I'm wondering, you had mentioned I have an adult name change. Now,
Okay.
would it be beneficial to transfer to my adult name change? The
No,
title.
put it in a trust.
Okay, just the trust.
Oh.
All right. So
That way-
I
that
don't have to do
way-
any other
Well, here's the reason. Here's the reason. If you fall asleep and hit two cars and kill somebody, you're going to be liable. But if it's in a trust, you're not the liable party. The trustee is. Okay. So that's why you want it in a trust. It's the liability issue. Yes, no?
Okay. Yes, I get it. But so now I did it as an estate. I put it in the estate of the straw man, and my name change as the executive office. Is that similar? Or is
Who appointed you executor?
that, I did.
How? Well, there's only one person that has the power to do that, and that's the grantor. Were you the grantor of the straw man trust?
Oh, are you saying I'm not?
Of course you're not. The
Oh,
government.
damn it.
is.
Government is.
You don't have the power to make that, to make yourself executor.
I still accepted it though.
You can't. You don't have
Okay,
the
so-
power. Only the grantor can make you the executor. Then you
Aha.
can accept it. See,
Okay,
this
so
is-
all
this is
of
what
that work I
mean
just did was,
about making false claims. You don't understand that you don't have the power to make that claim. You're not
aha.
in the position to make that claim.
Well, that's upsetting.
Yes, I'm sorry. But has anybody
do
got
it
mom and dad who has a trust? When they, the standard AV trust in the statutory world is when your mom and dad die, they assign an executor of the trust. Because they created the trust, they get to assign who the executor is upon their death, who gets to run the trust. Only the grantors have the power to assign a trustee or an executor. Period.
Okay, so if I have an adult name change, I thought I heard you say earlier that with the adult name change, the judge is actually giving you,
Okay.
that you have to accept it.
Did you do the deed of acceptance, and is it recorded as grantee absolute of the name into your trust? You didn't.
Probably not. I only did the Anna von Reitz
what I'm saying.
928 forms.
You haven't finished it.
Okay, so I still have that opportunity to take
Yes,
control.
now you get it. Now, that's what I wanted you to say. I wanted you to understand that you're halfway there. You just need to complete an imperfect gift. You need to complete the acceptance according to trust law. If you want the judge or anyone to recognize it, you got to do it this way. Okay?
Okay. The other thing is in the name change, the judge also ordered a change of social security number. Now, should I still finish that or just leave that alone?
I'm surprised he did, but it doesn't matter. You'll get a new bond anyways. If you take the name change order to the Social Security Trust or Social Security Administration, they're going to give you a new card with a new bond on the back anyways. Okay, so what really happens is you go from the trustee position of the Social Security Trust Because right now, you're the one that's always paying into Social Security, right? Until you reach the age of whatever, 66, or everybody is paying. Well, if you're the payee, look at the diagram, the payee is the trustee. So what happens in the name change, you make them recognize you as the beneficiary of the Social Security trust. Okay, that's what you're doing because you have the claim, a higher claim than they do to the name. Remember, the
Thank you.
beneficiary is the true owner. It's
So,
very powerful. It's very powerful
so,
name change.
so he wants to stay, the everything needs to go over the judge, over the Supreme Court.
No, what I'm saying is, if any time that you're involved in a court case, if you can prove you have the superior title to the name, you trump theirs. See, a state prosecutor is making a claim by legal characteristic on the all caps. If you have a judge's order that trumps that, you can say, I have the superior claim, dismiss the case. You have to have something that they will recognize that you have a superior claim to the name and to the estate. Does that make sense?
So it's
You are winning.
any court,
Yes. Well, what court is not gonna accept a judge's order? Do you see what I mean?
Mhm.
Of course they will. As
Yeah.
evidence. It's always about the evidence. I'm trying to teach from a position to give you evidence so all of these things can happen correctly.
So
Okay?
without the court, we cannot claim our name, or we have another way.
You can claim it. I don't understand your question. I'll be honest with you. You
The
know,
claim for the name, claim for the
Okay.
company, claim for the
What is your
trust.
proof? What is your proof? What is your evidence that you could bring to court that it's your name? That you have a higher claim? What evidence?
Okay,
Tell me, what evidence? I'm asking, I'm quizzing you.
I never been in the court.
Okay. The answer is the birth certificate. The certificate of live birth, and especially if it's double authenticated, is the evidence. Okay?
Okay, that situation. I'm from different country,
Yes.
right? I born
Yes.
from different country, and this country not exist anymore. I cannot get the birth certificate
Yeah.
authorization.
Do you have a naturalization certificate?
So it's working still the birth certificate. I have a
Do
birth
you have-
certificate on
Do you
a
have a
hand.
certificate of naturalization? Yes or no?
Yes, I have both on a hand.
That's all you
but
need. That's all you need.
but-
You don't need your original birth certificate. You just need
I need it.
certificate of naturalization.
Okay.
Okay?
And another question. How to reach the Social Security trust? It's a CSTQ trust. So how can we climb this trust correctly? That's
Well, who can make a claim on a trust? I told you this twice in the talk today. Only a beneficiary can make a claim on a trust.
correct.
So you have to
Correct.
claim you're the beneficiary of the Social Security trust. Okay? And it's the Sesta K trust, not the Sesta KV trust, that of course a lot of people say, Sesta KV, V means living. That trust was not set up for the living man, it was set up for the dead man.
Correct.
So don't call it a Sesta KV trust, it's not. It's a Sesta K trust. All right? You can create your own Sesta KV trust, but the trust that they have is the Sesta K trust. That's how I know immediately where most people are talking about, they know what they're talking about or not. That's one of those simple things I can tell if you even know what you're doing. Okay, it's not a Sesta KV trust. It's a Sesta K trust.
So we climb CSTQ trust and open new trust. It's going to be CSTKV trust when you get the position the living man, correct?
Well, some people have been able to get access to the Sesta K trust. What do they do with those funds? They transfer them and they buy trust into their Sesta KV living estate trust. So they set up a living estate trust for themselves, so they stay in the private and then they control everything. Okay, but that is a level that is, you know, probably 25 times higher than you're at right now. Okay,
Okay, I know the people who get access to the trust, but don't know what to do next, how to manage this trust and what to do.
They need to create a trust to transfer the assets into. They're not going to give them to the real man. They won't do that. Everything is in trust accounts.
Yes,
Everything.
yes,
They will
it
be
is.
glad to transfer from trust to trust, but they will not bring it out of a trust into the public. They will not do that. Okay, you can't do it that way. It just has to be transferred to another trust, which is done with a trust to trust grant deed. Okay, because you're going to convey from one trust to another.
Except.
You have to create that kind of a deed, not them.
Oh, that's why.
Yes, because only you have the power.
Okay, cool.
All right.
Thank
Next.
you.
Anybody else, any questions? All right, Tom, any closing words?
Learn trust law. If you need more diagrams, more reading, I'll give you articles on trust. I'll give you the videos I've done on trust, but just contact me for that kind of stuff. I'm just really trying to, I've been through it. I did the SBC process. I did all of that. Did everything that anybody's ever going to do. I did the ANA thing. I really never felt it was a success or I was getting to the things I needed until I learned trust law. Okay. I'm just trying to tell you my experience. And my experience sure tells me that trust law is the way to go, the way to learn. You'll be much more able to navigate the commercial world if you know trust law and stay out of trouble.
Yeah. Well, I think it made a lot of sense today, especially for me. So I think that's certainly the way to go. It was a great overview. I thank you for your time, Tom. We'll get all the information linked to the podcast from you, and I'll distribute it to everybody who was on the call today. So
All right.
thanks for your time. Appreciate it.
Well, bye.
Thanks, Tom. Thank you.